Well, welcome back to TuckerAllen Live. I'm Scott Trout. I'll be your host again today for this Friday edition of TuckerAllen Live, where we just spend 15 minutes with you or so to talk a little bit about some of the instances of estate planning and all those items. And I'm joined again by the TuckerAllen attorney, Teresa Yao. Welcome.
Hi, thanks for having me again, Scott.
Hey, thanks for joining as always. Make sure everyone to submit any questions you may have during this live segment in the comments section, just like last week, and we'll try to get to some of those questions for you while we're live. Otherwise, you can check out our town halls in the future and podcasts in which we'll address some of those questions, but we'll get to some of those today, just like last week. So let's get to it. In today's subject and topic, really, it's about trusts and terminating trusts. So Teresa, really, I guess it begs the question is, why would anyone ever want to terminate a trust?
So I guess the first answer is normally you don't. Unless you have a really good reason. A trust is a really good thing to have around and to maintain that peace of mind for you. But terminating it is an option. And really the two primary exceptions I can think of is if it just costs more to administer the trust than to keep it around. Like, for example, if the trustee is traveling a lot to continue his or her responsibility in administrating the trust, or if there's like financial consultancy fees, whatever it is, if it's just more costly than more like not as worth it to keep the trust around, that's a circumstance in which people might want to terminate a trust. Or let's say you created a trust when you were younger or when you're single and then you get married and you want to create a new trust, a joint trust together. So in that circumstance, you might want to terminate your old one so that you can kind of funnel all your assets together in that joint one. Vice versa, maybe you created a joint one, but you are getting divorced. And now you kind of want to create your own trust. So you want to terminate that joint one.
So basically, some life changes may lead to that decision. That's the right way. I mean, it could be like you mentioned, married or divorced, but there may be other life situations that would want you to consider terminating the trust, I imagine.
Yeah, so in terms of most major life changes, trusts are relatively flexible, so you can usually update them in order to mold with your major life changes, but there are certain life changes where it would require you to just create a new one.
So let's jump to the idea that it's a good idea to terminate the trust. And you've had a consultation, you've talked to an attorney about it, on some of the factors that you just mentioned occur. What are the ways to terminate the trust so people kind of get an idea of how it goes about?
So yeah, I guess the number one way is you can just actively choose to terminate a trust. This is when you're still alive. I guess the big cautionary tale about this option is that you want to make sure that your trust is empty when you terminate it. You don't want to make sure you have all these assets in the trust and you terminate it, and then what happens to these assets because that they were owned by the trust or that the trust is the beneficiary. So you want to make sure that you're actually taking care of those assets inside of that trust before you close off that basket. And then in terms of terminating it, the formalities are just very similar to the creating of it. So just getting it notarized, signed, stuff like that.
Other ways. Let me real quick. It seems so counterintuitive. I mean, like all last week, and I know we'll talk about some of the questions that have come in. Hey, build a trust, make a trust, do a will, do this powers of attorney. And now we're talking about getting rid of the very thing that we're trying to tell someone to do it. It just seems, I know people are watching and thinking, I'm confused. I guess it always falls back on, as you suggest, and want to kind of key in on the things you said. Make sure you've exhausted everything in the trust, right? Meaning that the property is no longer there, the assets are gone, whatever it may be. And so therefore the trust itself is too expensive to maintain.
Yeah, exactly. So like I said, like the main takeaway is, hey, keep your trust around. And we'll get to that later on in terms of, okay, there are other things that happen in your life updates. Definitely explore the option of updating your trust before you explore the option of terminating it. And then maybe speak to an attorney about which option makes the most sense for you. We really don't want to terminate a trust unless there's a really good reason to.
So does the termination, I mean, obviously the trust may survive the person who creates it, I imagine. So they may pass away, and depending upon how you created, you may say distribute assets over time. I guess that's a way in which the trust would be terminated at some point when they distributed all the assets itself, and therefore it has no purpose whatsoever, right?
Yeah, exactly. So that first way about actively terminating your trust, your successor trustee, like outside of the grantors, the other trustees that come later on can't really actively terminate it. but they can terminate it after, like, under two different options. One is the trust has done its job, the trustee has distributed the things, there's really no point in keeping it around, the trustee can terminate it at that point. But the other option is if the trust property, inside of the property, you can set an amount saying, hey, if it's under a certain monetary amount, all the assets together in the trust, then maybe it's not worth it to keep it around anymore. And then the trustee that way has this provision built in as an out to terminate the trust.
So don't forget, as we're talking, I know I have questions and I'm throwing them out. If you have questions and you're watching right now, go ahead and submit them in the comment section. We'll try to get to those while we're briefly talking a little bit about this topic. So I guess the question for you, Teresa, is, as you mentioned, that it's no longer needed, the assets have been distributed. I know one of the questions that I'm going to ask you later, and we'll get to it, is about planning for medical expenses or long-term care. Imagine if you've put all of your assets appropriately in a trust, now that you've spent whatever is necessary down, or whatever it may be. Those are the situations you need to have that conversation about whether or not the trust should continue or not.
Absolutely. And normally, in terms of preserving assets or wanting to make sure you protect your wealth as you think about more healthcare costs later on, it doesn't really mean that you have to terminate your current trust. It might be that you want to add on a different kind of trust that provides more protections for those assets.
Okay, so we talked about terminating and what it means. We talked about the different ways. So what happens now? Let's say we've made the decision and then reached the conclusion, and you're recommending terminate the trust. What happens when a trust ends?
So when a trust ends, and let's say it ends because you finished distributing everything, then that's the end of the line. Then the trust just doesn't exist, and good for it. But if there is, for whatever reason, still some remaining property in the trust when you try to revoke it, it would just follow if you built in a contingency clause in the trust saying, hey, if it's revoked, this is how I want my remaining property to be distributed. It would follow that. But if you don't have that contingency clause, it's kind of this gray area where the beneficiaries and the trustee have to work together to figure out a fair way to divvy it up.
So kind of what you said, I want to jump back to the previous where we talked about the different ways to terminate it. So you can control, if I'm creating the trust, can I set a level of assets by in the trust? Let's call it 25,000. If the assets fall below that, I can say the trust should be terminated at that point and kind of provide for that?
Yes, absolutely. So you can say, hey, trustee, we've both passed away, but if you find that after however many years, as assets are being distributed throughout the years, if it ever falls below $25,000, then we acknowledge beforehand that that's just not as worth it for you to administer. So you can take that out. You can decide whether you want to terminate it or not. And then it gives that trustee that discretion. So
it's just an effective built-in way to save the trust money and make sure that the assets go to where the person wanted them to go, rather than spending them needlessly on trust administration fees, which just sounds crazy. I get it. I mean, it's one of the things that you don't think about, the termination and then the cost of it, but it is important to make sure that you do that.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
People have questions. Maybe they have a trust right now. They've got the will, they've got the whole package, but how do they update it? And can they update their trust to make provisions in this regard? And how do they go about updating a trust?
Absolutely. So like I said, hopefully you consider updating before terminating, right? So when we think about updating a trust, there's really two ways, either through an amendment or a restatement. An amendment, think about it as update light. So it's only making the smaller changes, like if you want to update the name of the trustees, like change up the people or certain distribution percentages, like let's say you have 50-50 right now to your beneficiaries, but you want to change it to 25-75. So pretty simple, straightforward changes you can do through a trust amendment. However, if you want to kind of change it all up, because like for example, changing from an outright distribution to a periodic distribution, or just the pattern in which the structure in which your trust is set up, you would want to do a restatement. A restatement is essentially your trust keeps its own name, it keeps its first creation date, but you're just changing pretty much all of the terms of the trust to update with your life circumstance.
So is there an advantage to a restatement versus an amendment, really?
The advantage of a restatement is it is like we wouldn't want to use an amendment to do a thorough clean through of a trust, because amendments, the function of it is really just to tweak it, but a restatement is to morph it.
So a major update would be the restatement, as you're saying, right? Just a complete overhaul.
Yeah,
and
so
then, there may be.
Update, and a restatement is update full.
So restatement would be just basically revoking a previous one and just completely doing a new trust.
Well, so no. So there's a distinction between a restatement and creating a new trust. And a lot of times people come in, they're like, oh, I have a really old trust, and then so let me just create a new one. And I actually tell them, no, we want to keep your old trust. Because all the homework that you did with your old trust in terms of funding those assets into the trust, going to all those financial institutions, changing those beneficiaries, you don't want to waste your effort from back then, because those assets were titled in that old trust's name. So a restatement preserves the titling of those assets, but allows you to change the terms of the trust.
Now that makes sense, because I know people are thinking, we often as lawyers tend to use the words that we're familiar with that no one else knows, but that totally makes sense, meaning that if you've funded the trust, you've retitled assets, rather than going through all of that pain, because trust me, I know funding the trust is not easy, and you want to pay your lawyer to do it, because I've tried to do it on my own and it's not fun. I get it. So now where you don't want to just start it over unless you really have to. So people that are watching really should have that conversation if they need to update things. It really is a conversation about whether it does need a complete overhaul. Obviously things have changed, or provisions we talked about, I think was the CARES Act you mentioned, that has some really important things that you need to talk about if you have retirement assets or something to that effect that are in it. So continue. If you have questions, make sure you submit those in the few minutes that we have left in the comment section. We'll try to get to those. But one of the questions is this. So should you have the assets in a trust? We talk about the termination of a trust, and we talked a little bit about that last week when we talked about durable powers of attorney. But the question, I think, was from Evelyn, should I have them in a trust, and what kind of trust should I be having?
Could you repeat that last part of the question?
Oh, sure. What kind of trust should I have?
So it depends on what kind of priorities you have, right? So a regular revocable trust, that helps you prevent your assets from going through probate. But if your goals are really kind of asset protection, preserving it and making sure it doesn't really fall under like those healthcare bills that might mound up later on, then you would want to consider creating an irrevocable trust in addition to your regular revocable trust. Mainly because the irrevocable trust actually helps you achieve that goal of protecting those assets to be passed down.
Got it. So one of the questions also came from Katie. Does setting up a trust sooner help protect and insulate inherited assets?
Yes, in the sense that if you inherit assets and you don't set it up within your trust, then those assets, as soon as they're yours, they could be up for probate if something were to happen to you. So you might as well set up a trust earlier on so that your inherited assets can go inside of your trust and avoid that probate process.
And I know we talked about this last week, in terms of taking action, if not now, when, meaning, during a pandemic, it's the things like this become front and center, not in a morbid way, but in a way that just knows that you have peace of mind in the unknown, that you can plan. And that's why when she used the words, setting up a trust sooner, it should be setting up a trust now. I mean, there's just no time to wait at this point, especially when you're going to get assets like that. I think, as you suggest, it's more important to just start planning even before they're ready to come into
and that's actually kind of a prime time to set up a trust, because if you're getting inherited assets, if you're getting it through a trust or whatever administration, you can even tell those trust attorneys, say, hey, I'm setting up a trust. Can you just give it to the trust instead of to me first, and then I'll do the homework. So you can kind of skip some of your homework if you just set up a trust for those inherited assets to go into.
Right. Again, if you have any questions, submit them in the comment section right now. We'll get to those with the last minute or two that we have. Last one from Kevin, maybe a little bit more complicated. It says, how do I protect personal property, house and cars, when nursing and medical bills mount? So I'll get to the second and the third part of that question, but I guess that's really about elder planning is kind of what TuckerAllen also does. It's a little bit just wills and trusts and elder. And everyone really gets confused in what that means. But maybe that's what Kevin's asking is, how do I protect everything when nursing and medical bills are getting to mount?
Yeah, so this kind of brings me back to that irrevocable trust that we talked about, because that's the only trust that can actually really protect your assets against nursing home bills or other medical bills, long-term care wise. In terms of protecting those specific personal properties, you can set up, we do with this assignment of personal property that you can say, hey, by default, my furniture, all my goods are going into my irrevocable trust. And then that way, you would want to make sure you plan ahead ahead of time so that those assets can be protected. And then with long-term care, a lot of times you kind of have to wait for a certain time to pass before that asset protection kicks in. So I would say for the irrevocable trust, plan sooner than later as well.
And I think Kevin was talking about this in our virtual town hall. We talked a lot about planning and trying to protect your assets so you don't have to spend them all in a facility later on. And there's really good ways as long as you take advantage of them early. And, I think he threw out like a 5-year time period just in advance. And that's what elder law, and that's what you all do, is to try to protect the assets so you don't have to use them for your care in a medical facility. And I think that's what Kevin's suggesting, because he says, when do you have to surrender your savings and home to the caregiver? So I guess that you may have answered is with appropriate planning in advance, you don't have to, right?
Exactly. So that 5-year number is usually that magical number of years where you say, okay, this is why it's important to plan early, right? Because then you can say, okay, 5 years or more ahead of time, if I've done this work, that's protected. None of that has to fall to any other creditors or long-term care costs or anything. So
they would qualify for aid instead of using their depending upon, I guess, income levels, but instead of using their assets, they could qualify for some assistance.
Absolutely, yes.
And then the last one, he talked about how much do you have to surrender, and I guess that really depends on how much the estate is or how much an asset you have, right?
Yeah, for that question, we'll have to meet with Kevin personally, get the numbers, run the numbers to figure that out. So
yeah, and that's part of, though, I think the second part of what TuckerAllen does, which I think is unique, is it's not just wills, it's not just a trust and planning for the future, but it's that elder estate planning that talks about in the event that you need to go to a facility like that, you can really protect it and direct the things you want most to go to who you want to go rather than to the facility, right?
Right, exactly. We want to plan ahead. Like we're talking about terminating trust at the beginning, but really the most important thing to take away is, hey, you can create multiple types of trusts that achieve different aims.
Yeah.
And for the asset protection one, we have trust for that, and that's under our elder law service.
And that area gets so complicated because there are a lot of people, when I know you did seminars in the evenings with people that would come in and you talk a little bit about how to protect your assets. It really encouraged people to just come and find out, have a Zoom conference or Zoom consult with you or one of the other attorneys, because it just really hear more about what you can do, because it is a complex area that requires some in-depth conversations about the assets. So I would encourage everybody who's listening and watching right now to do that. So Teresa, thanks. I know we're running out of time for our Friday segment on TuckerAllen Live. So thanks for joining. Appreciate it.
Thank you.
Well, if you have questions, I know you do, I continue to do each week, you can reach TuckerAllen, or you can go to the website and schedule a consultation at TuckerAllen.com. You can check out all the material that they have with the virtual town hall and podcasts and other videos, things to educate you and to get you the information you need on TuckerAllen.com as well. Or you can give them a call at 866-335-3375. They have offices in the Kansas City metropolitan area, including in Kansas, St. Louis metropolitan area, including over in Illinois in Edwardsville. So until next time, thanks for joining Facebook Live. We'll talk to you next week with another topic, bringing you information on how to protect and how to plan, because if not now, when?